Yes, I do present myself, yes.
All right, but you wish to continue to represent yourself, is that accurate?
Yes, I continue to present myself, yes.
All right. All right. Mr. Hensley, how are you today?
Objection. Milton Bey.
All right. So, Mr. Hensley, we've been through this before. I'm going to call you by the name that's found on the information here.
You have my nationality information.
Are you representing yourself today, sir?
Propria Sui Juris.
All right. So, Mr. Hensley, I'm not certain what you mean by that phrase. All I'd like to know is whether you're representing yourself today or not.
Well, you don't know what Propria Sui Juris is? That means somebody presenting themselves.
Hey, Deputy, I want you brought over here in person. We'll put this all on the record. We're going to put this on the record in person. We're going to get Mr. Hensley sentenced today, and we'll make a complete record, as complete as we can, but I want to do that in person because we can do this all morning via Zoom, and it's just not very conducive to that. By coming up on them at a high rate of speed and following it down that closely.
Objection, man.
Mr. Hensley.
I drive a BMW. Anybody with an autopilot vehicle, you know for a fact it won't do that.
Right.
That's a fact.
So, Mr. Hensley.
Not what he giving you out of his mouth. A fact. An automobile will not get up on nobody. Automatically jam brakes. I told you BMW does that.
The trial is over. You had an opportunity.
Welcome to a masterpiece compilation of several hearings from an extremely intriguing case out of Michigan. We've combined all of his courtroom appearances into one seamless video, complete with timestamps and chapters for easy navigation. In part 1, you'll witness Milton enter the courtroom walking with a cane and projecting the image of a subdued, harmless old man. His soft-spoken, mild-mannered demeanor might initially lead you to believe he poses no threat, but don't be deceived by appearances, and make sure to stay tuned until the very end of this wild journey. Because part 3 is where it all culminates, with the defendant facing some serious charges and ultimately being sentenced. Despite the gravity of the situation, and in classic sovcit fashion, he has chosen to defend himself pro se, refusing to back down, even in the face of dire consequences. As this saga unfolds, you'll see his true volatile nature emerge as tensions rise between he and Judge Schaffer. This is one sovcit courtroom debacle that you don't want to miss.
Mr. Bey, why are you not here today?
The schools and everything are closed today, so I ain't have no babysitters or anything at the last moment. All
right. Well, you do have some motions, and you also have a sentencing date, but I need you in person for this today. All right. You gonna be able to get over here later this morning?
I'll try to be on my route right now, Islam.
A few moments later.
People be Milton Hensley Jr. This is case number 23S18766FH. The defendant is present in person.
Object. Compilation is Milton Hensley Bey.
So 2 things here. So this bond, so today it looks like we just have his motions today. We don't have a sentencing. So we don't have a PSI completed then.
Correct. I'm still waiting for the referral from the prosecutor's office, so I don't even have a date yet, but he did come to the office.
Okay. All right. So Mr. Hensley, then I thought we had a sentencing date today. So it's just your motion today. So just like I have every time you're here, I got to go through these questions with you. All right. And I want to make sure we cover them. Yeah, go ahead.
My Honor, my name is Milton Hensley Bey.
Yeah, I tried to remember that, Hensley Bey. All right, go ahead.
And I come before this honorable court today to respectfully address a matter of significant importance related to the case at hand. I hope to present this statement with clarity and transparency. On the 8th of January 2024, my Honor rendered a judgment following the trial proceeding in this matter. Subsequent to the judgment, I, Milton Hensley Bey, filed an appeal with the Michigan Court of Appeals. The appeal has been accepted and is bears a claim of appeal number 369382. I am compelled to inform this court that I am impelled to inform this court that in the light of ongoing appeal process, I find it necessary to request a stay of the proceeding in this court. the decision of the Michigan Court of Appeal will likely have a profound impact on the direction and resolution of this case. Furthermore, Your Honor, I must express that during the trial, my request for a continuance was denied, hindering my ability to adequately prepare for the proceeding. Thus, compiled with my current indigent status, present substantial challenges, I am unable to afford the costs associated with obtaining additional transcripts, filing experiences, and even basic living costs as I navigate through this appellate process. In consideration of my indigent status, I respectfully request that the court waive the bond option or any bond requirement in this case. The financial constraints I face make it impractical for me to meet the financial obligation associated with posting a bond. Waiving the bond requirement would ensure that I can effectively participate in the ongoing legal process despite my financial limitation. I humbly move to this court to enter in order to stay the proceeding in consideration of the pending appeal with the Michigan Court of Appeals. My Honor, I overstand and comprehend the gravity of this request and assure that the courtroom that it is made in the interest of justice and the fair adjudication of my case. I am grateful for the court's attention to this matter, and I am prepared to provide any additional information or clarification deemed necessary by the court without self-incrimination. Thank you for your consideration, Your Honor. Respectfully, Milton Hensley Bey.
All right, so Mr. Hensley Bey, I do have to ask these questions again, so they're going to sound familiar to you. So you've got this motion before the court scheduled today. You do understand that you have a right to have the assistance of an attorney at any stage of the proceedings. This is another stage of the proceedings. Sir, are you waiving your right to have an attorney? You continue to want to represent yourself, or would you like the court to appoint an attorney?
I'll continue to represent myself.
Very good. And then you understand that if you can't afford a lawyer, the court could appoint one for you. Would you like the court to do that?
No.
Okay. You understand that the charges that have been brought against you and now that you've been convicted of, those are serious charges. They, again, are the charges of, let me pull the information here. All right, count one is carrying a concealed weapon. That's a 5-year felony under a $2,500 fine with mandatory forfeiture of the weapon or device. Count two is assault with a dangerous weapon. That's commonly known as felonious assault. That's a 4-year felony under a $2,000 fine. A consecutive sentence can be imposed if the assault was committed in a place of confinement. And finally, count three is felony firearm, which is a 2-year felony. However, it's 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction, along with mandatory weapon forfeiture of the weapon or device. So again, do you understand the nature of those charges and the maximum penalties, sir?
I comprehend.
All right. And then,
Sovereign citizens often refuse to admit that they understand anything because they take the word understand literally, interpreting it to mean stand under or be subordinate to someone or something. This tactic is part of a broader strategy to reject the court's jurisdiction. Sovereign citizens often engage in various linguistic tricks in an attempt to avoid acknowledging the court's authority over them. By refusing to say they understand, they believe they are avoiding any admission that could be construed as accepting the court's power.
all right. And as it relates to count three, that's worth some, I guess, a special acknowledgement. We've talked about this previously, but that charge by itself requires the court to sentence you to 2 years in prison, which you would have to serve before you would begin to serve any sentence on counts 1 and 2. Do you understand that?
Comprehend.
And knowing that, you still wish to go forward representing yourself.
I represent myself. Yes.
Very good, sir. Do you understand that there's risk of representing yourself?
I do not understand.
You understand that there's risk of representing yourself because the other side is represented by attorneys, and the court will be required, as I have throughout the proceedings, to hold you to the same standard as an attorney, and the court couldn't give you any special consideration or assistance, if you will, with your motions or defense or anything of that nature. In other words, I have to treat you the very same that I would the other side, and they're represented by attorney. Do you understand that?
Hernan versus Kane said you can't treat me as a jurist because I'm not one.
All right, so we did go through that. You did raise that motion earlier. Court has a different interpretation of that case and what it meant as it relates to pleadings and not actual motions or trials. But do you understand, though, that you could be at a risk of by representing yourself, and that you are not going to have the training, the experience, or the education that the other side does?
I comprehend. I comprehend.
Okay. Do you understand that I have to require you to follow all the rules and the same requirements that apply to lawyers in this courtroom? You understand that?
I don't understand that.
Okay, so I just went through this. Do you want to represent yourself? The court has to treat you the same as the attorneys. I can't give you any special help or relax rules or something like that simply because you're representing yourself. Do you understand?
I comprehend.
Very good. That's a long way to the court saying I can't give you any special treatment if you want to represent yourself. Do you understand that? Okay. Would you like the opportunity to either hire an attorney or just talk to a court-appointed attorney before we keep proceeding today?
No, we're not.
And then do you agree if we go forward with your motion today that you'll follow all the same rules that the attorneys and anybody else appearing in this courtroom are going to be subject to?
Comprehend.
Okay. Mr. Butler, do you have any questions regarding his waiver to counsel?
No, thank you.
All right, you believe the court's complied with MCR 6.005?
I do.
All right. So as far as the court is concerned, Mr. Hensley Bey has represented himself from day one in this case. The court has tried to run through all of the questions that have been provided. Again, when we do this, I don't mean to insult Mr. Hensley Bey's intelligence. It's just something the court is required to do, and it might, from his perspective, seem like, why do you keep asking me these same questions? I want to represent myself. I have a right to do that. And you're correct, but we do need to do this each time, at least this court's interpretation, each time that you appear, because you certainly have a right to change your mind too. You want to hire an attorney or ask for a court-appointed attorney, we can do that also, and then delay the proceeding until you retain or have a court-appointed counsel appointed. All right, so I do find that your waiver today, again, is knowing, intelligently, and voluntarily made. I would characterize it as unequivocal. Again, Mr. Hensley Bey has been steadfast in his desire to represent himself. I believe the court has, and Mr. Hensley Bey has also acknowledged the dangers of self-representation, that he'd be held, in essence, to the same standard as anybody else, court rules, rules of evidence, those types of things. And therefore, the court will then allow Mr. Hensley Bey then to proceed today. He has a motion before the court to stay the proceedings pending appellate decision. Now, this is one of those things, again, comes up when folks in representing themselves. He has filed his motion, scheduled it on for today, it appears. But he's also filed a claim of appeal. At least in this court's opinion, that claim of appeal is premature and that Mr. Hensley Bey simply has not been sentenced yet. So to the extent the court has one here in front of me, a claim of appeal that appears to bear his signature and was dated January 16th, that's not something the court would consider or can consider, at least in the court's opinion, because he's not yet been sentenced. Now, this is something he certainly can file post-sentencing, but that leaves us then today to the motion that was filed, which is simply a motion to stay the trial court proceedings. Mr. Hensley Bey, is there anything you want to state this morning in support of your motion to stay the proceedings, which would mean, in essence, the sentencing date that is, I don't know that we have a date yet, do we?
No.
That will occur at some point in the future.
One thing I have to add, John, is what I just read to you.
Okay.
Motion to stay, granted that everything been done, cases over with the Court of Appeals. They gave me a number and everything, so the case is active. And I just ask that you, give me a motion to stay where we can get everything in order, because I also paid for the transcripts, and I was told it would take maybe 3 months before I can get them. So I just rush to the court to give me that time, render their time to get these things in order.
All right, then Mr. Butler, what's the people's position on Mr. Hensley Bey's motion to stay?
So, Your Honor, I did receive motion, I suppose, from the defendant, it looks like sometime in maybe January. And it's titled motion to stay court proceedings pending appellate decision. And it is 3 pages in length. Last night, I received an email about 7:25 p.m. from someone other than the defendant, Curtis Sean Joseph Bey, sending an email, it appears on behalf of the defendant, with an amended motion for stay of execution pending appeal. Did that get filed with the court?
I've not seen it, no.
Okay. So I suppose I won't address that then. Just looking at what
It was filed on the 22nd.
So, but Mr. Hensley Bey, that raises a different question I'm concerned about. So you've consistently represented that you want to represent yourself. This would sound like this is a third individual that's filing something on your behalf.
No.
Is that correct?
Yes.
Okay. Who's the third individual?
You told this Curtis Bey.
Curtis what?
Bey. Sean Bey. Yes.
Curtis Bey. So is that a relative of yours or something?
Yes.
Okay. Is he an attorney?
He have information.
All right, but he's not an attorney.
That's my knowledge. No.
All right. So because it's not been filed with the court, certainly Mr. Butler has raised it, court would not consider that today.
No, it's been filed. It was filed on the 22nd.
I don't
That's
have
right,
that. We'll have it. Hold on. We'll have Mr. Geiger, our clerk, is going to search for that. But even if it was filed on your behalf, if it's not an attorney, and you've indicated to the court you want to represent yourself, courts can't consider that anyway. All right, because a non-attorney cannot represent you. You can represent yourself, or you can have an attorney represent you, but you can't have a non-attorney that's represent.
According to my nationality, Moorish American, we have counsel, and that's how we do with counsel.
Yeah. Well, I'm not aware of a court rule that would allow the court to have a non-attorney practice law. So that's a bridge we can cross, I guess, if and when we get it. But then, Mr. Butler, I would like you to address Mr. Hensley Bey's motion to stay the proceedings.
Thank you. Then just focusing then on the January 10th motion that was filed. The defendant doesn't give any rational basis for the stay of proceedings. There's no citations. There's nothing, no court rule, or case law, nothing like that cited. What the defendant does cite is Rule 6.004 in regard to speedy trials, which is wholly applicable to this case altogether. The defendant's not in custody. He's not an inmate, a prison inmate. It just does not apply. And so with that, we would ask Your Honor to deny the defendant's motion based on lack of merit, lack of grounds.
All right, Mr. Hensley Bey, I am going to deny the motion for stay. Mr. Butler's correct in reviewing what you have filed here, and it's a 3-page document. The third page is just a signature page. It looks like there is no grounds that has been cited that the court could rely on that would make sense for a stay. Now, you certainly still have a right. I'm going to deny that, but you certainly still have a right. You can file a request to stay the proceedings in the circuit, in the appellate courts. In essence, I think what you want to do is you want to have a adjournment of this, or stay of the proceedings, if you will, to have the court review something that is not yet right, which is the outcome of your trial. And it's not yet right because you've not yet been sentenced. So I'm going to deny that motion. I'm going to ask Mr. Butler to prepare an order that says your motion to stay the proceeding is denied. Now, if you do file something with the Court of Appeals and they grant your request for a stay, they would inform the trial court that the proceedings have been stayed.
Can I get that?
And then we would go from there. What's that? All right, so just for the record, so the clerk has just handed to the court a filing that occurred yesterday. It is titled Amended Motion for Stay of Execution Pending Appeal Bond to be Waived. It's 1, 2, 3 pages in length. That is filed by Milton Hensley Bey, and that appears to be, were these other pages attached? Exhibit for a motion to stay?
I believe that was.
Okay, so then there's a third page that says exhibit for a motion to stay, case information, case header, case number, Court of Appeals 369382. Second page is citing looks like the parties, Allegheny County prosecutor, and then Hensley, Milton, Joseph. 11604, it's or 24, incomplete filing, order appealed from trial court on the circuit court, and then my name is the trial judge. Motion waived, transcript was requested, defective holding file letter. All right, so that looks like, I guess it could be, it's a copy. This was filed with the clerk's office, maybe what Mr. Hensley Bey has been referring to. He had something up a moment ago. So it looks like maybe he did file something with the Court of Appeals. So if you did, sir, this court certainly will take direction from the Court of Appeals if they give us some sort of indication that they have stayed these proceedings, or they will give you additional direction along with the court, what they are looking at as it relates to this filing, whether they have accepted it, rejected it as being incomplete, or something of those.
But they said accepted it when they give me the number. That number you just read out there,
Yeah.
369.
Yeah.
382.
Mm-hmm.
That was the number that they when they give it to me.
Right.
The number is accepted.
Yeah.
So that's why I came when they gave me the information. That's why I presented the information to y'all yesterday. When it was also presented to me.
So that's been filed with the clerk's office, but it doesn't change this court's opinion about the motion that was properly before the court today, which was a motion to stay the proceedings. I'm going to deny that. I'm going to ask the prosecutor to prepare an order that indicates something so I can sign it, and then you certainly can get a copy of it from the clerk's office so that we're all on the same page. Now, again, if this, meaning this filing that I was just handed, results in some sort of direction from the Court of Appeals that your case has stayed, meaning the sentencing date, that we're going to stay the proceedings and the only thing left would be a sentencing date, then certainly the court would follow that directive. But right now, I'm denying your motion to stay the proceedings. Then you'll get a copy of it. You'll have a chance to check it for accuracy so you can let the court know when we come back for sentencing if there's any information in the report that is inaccurate, then we can get those corrections made so we have accurate information on which to base sentencing. So
can you also give me a ruling on, because when I also asked the court, because of my financial situation, can you waive some of the transcript fees and the filing fees?
So it was my understanding that the court already signed a waiver, didn't they? I thought you were given a waiver. Yes?
For court filings.
Oh, for court filings. Okay, for transcripts. So maybe, so Mr. Hensley Bey, you did file a fee waiver request. You indicate you receive SSI. And you didn't fill out any additional information as it relates to income. So there's a box 3, your household income, the number of people in your household, your source of income. The court did review this on the 11th, it looks like. At that time, the court denied it because I didn't have all the information, income information had not been provided. So if you want to complete this, I certainly would review it again today. So it's that box 3 if you want to approach. Thank you. All right, thank you, sir. So for the record, Mr. Hensley Bey has returned this to the court. So we have a gross income of $1,900. Is that every week or every 2 weeks or a month?
No, that's once a month.
Once a month. All right. And the source of the income is the SSI. Mr. Hensley Bey, it's curious to the court. When I'm looking at my notes from the trial, you indicate you're on this supplemental income, Social Security, if you will. I guess not supplemental, Social Security. But the testimony from both the 404B witness from the prior incident you had in Grand Rapids and then this incident I recall you were driving a newer BMW. You might have been driving a Mercedes with the incident in.
And it was my vehicle.
Grand Rapids. Whose vehicle was that? What's that?
It must the BMWs for steroid.
Okay. Did you have a different sort of income back then? No.
The Range Rover, the Range Rover was 2011 automatic vehicle. Somebody I knew, somebody I was affiliated with, kind of helped me.
Okay. And then the other thing that's troubling to the court, as I'm handed this and you've finished filling it out, I think my administrator indicated you came in and paid cash for your transcript already. Is that accurate?
Yes.
Okay. So is the cash part of your $1,900 a month?
Yeah, man, I'm depleted. That's man, I'm 50 years old, so everything I had saved, man, that's what it was.
All right. So here's, I guess, my question. I don't know this. Do you know, was that the amount that was provided by Mr. Hensley Bey? Is that the full amount of his transcript, or is
Estimated full amount.
that's estimated full amount?
Mhm.
All right. Well, here's the issue with that. Mr. Hensley Bey, my understanding of the court rule is the fact that you are receiving Social Security makes you eligible for a waiver. So I'm going to sign your waiver. I'm going to redate it today. Now, if you want to use that to hire an attorney for your sentencing date, you're welcome to do that. You're welcome to continue to represent yourself. Do you have any questions about anything?
Just gratitude for what you did to you.
All right, so I'm going to give this to my court staff, and I'm going to ask you to step over to the clerk's office, or not, to the circuit court office, which is right outside this door. You can talk to my administrator. What I'd like you to do is I'm going to have her draw up a piece of paper. You both can stand there and count the cash, and then you'll acknowledge that I don't know what the amount was, but whatever you gave to the court is being returned to you. I'd ask that you sign and acknowledge that. All right.
Okay, gratitude.
Okay. They're going to contact you, meaning probation, to finish the PSI, and then once that's done, we'll give you a new sentencing date. Okay. I apologize. I thought this was the sentencing date. You do need to be in person for the sentencing date. If this was just a motion, had I known that, I would have let you appear remotely. But I thought you were here for sentencing. All right. So I know that you appear for your court date, so I'm not concerned about that. Mr. Butler, anything else?
No, thank you.
Okay, you're all set today, Mr. Hensley Bey.
You have a order for me?
Sure.
You have a order for me? To deny the motion?
All right.
No, I don't know. My office needs to print it, prepare to print it.
I'm gonna wait for it, then bring it to the federal court. Okay.
Okay, yeah, that's fine.
Gratitude.
All right, and then we're going to continue with our docket. So you're all set today. You're free to wait. Mr. Butler.
Yeah, if we can call the case of People v. Milton Hensley, 23S18766FH. I do see that Mr. Hensley Bey is on Zoom. They set to apparently address his motion to stay.
All right, Mr. Hensley Bey, how are you this morning, sir?
I'm all right, John. How are you?
I'm good. So I feel like last time I saw you, we already addressed this motion, but let me flip back through the file.
Well, this motion here is at the Michigan Supreme Court. And
Let's hear. Let me see. Let me find it. 1 second. All right. So Mr. Hensley, I think I see where we're at now. So it looks like court denied a motion to stay proceedings on January 23rd, and then there was an order from the Court of Appeals on January 26th. So 3 days later, it looks like that your claim of appeal was dismissed, and then you filed on February 9th a notice of appeal to the Supreme Court. I'm trying to find the exact verbiage here of your motion. The motion to stay execution pending appeal of the bond to be waived. Okay, so we can hear that quick then, sir. I do have to go through these series of questions. You probably know them by now as well as I do, but I still have to ask them all. We'll have to go through all of that, sir. So if you raise your right hand, I'll have you sworn, Mr. Hensley Bey. Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I affirm.
All right, you can put your hand down. All right, Mr. Hensley Bey, as I've noted, we've gone through this several times. I just need to find our list here. But you are appearing here today representing yourself. And is that what you'd like to do today, is to continue to represent yourself on the motion that you have filed asking for a stay of the proceedings?
Yes, I do present myself, yes.
Sovereign citizens often avoid the word represent because they engage in literal and pseudo-legal interpretations of language, which they believe can affect their legal standing. They interpret represent in a way that fits their ideological beliefs, often taking the word literally to mean they are representing themselves as something or someone other than their natural or sovereign self. In legal terms, to represent simply means to act on behalf of oneself or another in a legal capacity. It does not imply any loss of sovereignty or identity, as they believe. This is another example of the word games they play in an attempt to reject the legal system's authority, although these tactics have no basis in actual law and are consistently dismissed by courts.
Present myself, yes.
All right, but you wish to continue to represent yourself, is that accurate?
Yes, I continue to present myself, yes.
All right, and then, Mr. Hensley Bey, do you understand that representing yourself can cause you to be at a disadvantage, particularly as it relates to the people who are represented by attorneys, and recognizing that you could be at a disadvantage, you continue to wish to represent yourself, is that accurate?
Correct.
Okay. And Mr. Hensley Bey, as I mentioned before, that if you wanted to, you could ask for an adjournment. I'd actually grant you that adjournment. If you wanted to hire an attorney, are you waiving your right to go hire an attorney then?
I have outside, if I need outside counsel, I can get it. Gratitude.
Okay, but you're not requesting an adjournment to go hire an attorney and have them represent you on this motion, are you?
No, I'm not.
All right. And you also understand that if you were eligible, you could petition the court for an attorney at no expense to yourself. Are you waiving the right to request court-appointed counsel?
At this time, yes.
All right. And this, Mr. Hensley Bey, do you understand that if you go forward representing yourself again this morning, as you have in the past, that the court is going to be required to treat you the same as I would any other person appearing before the court, whether attorney or not? Do you understand that?
I do not, but
Well, when you say you do not, we've had that argument before in a motion, right? So you're referring to the idea that you thought that there was a case out there that would suggest the court has to give you a lot of deference or wide latitude because you're representing yourself. Is that accurate?
Kearney versus Hand, yes, ma'am, yes.
All right. And then we have debated that in the past. The court has denied that, saying that I don't believe the case stands for that proposition. And then if you go forward today, again, I'm going to have to treat you the same as I will Mr. Butler or any other representative from the people. Do you understand that?
I comprehend, yes.
Okay. And then, Mr. Hensley Bey, again, I'll remind you that the charges that you're facing are serious. Those are 5 years of incarceration. That's a maximum penalty on the carrying a concealed weapon charge. Up to 4 years of incarceration on the assault, felonious assault charge. And then the big one here, this felony firearms, is a charge that carries a maximum penalty of 2 years consecutive with and preceding any term of imprisonment. So again, explaining that you'll have to serve 2 years, no discretion by the court or anybody else. It has to be 2 years before you begin serving any sentence that would be associated with 1 and 2. Do you understand that those are serious penalties and that there are risks by you continuing to represent yourself? Do you understand that?
I comprehend. So the time went up on the charges, or because the last I was heard, it was 2 years, 2 years. So now one is 5 years?
Count 1 is 5 years. Count 2 is 4 years, and count 3 is the 2 years consecutive to 1 and 2.
I ain't heard nobody.
Same penalty that I've read to you over and over and over.
Yeah, I don't remember the numbers being that large, but okay.
All right, but I have to give them to you again today, like we have, and you still wish to go forward on your own? Is that accurate?
I still present myself.
Very good. Do you understand that as it relates to rules of evidence, court rules, that if you continue to represent yourself, the court will have to hold you to those rules, just as I would any other attorney appearing in the courtroom?
So is that the same when you talking about my constitutional rights? When you say the court rules?
Yeah, you certainly have constitutional rights, but as it relates to the court rules, the court will have to hold you to those like I would anybody else, including attorneys. So in other words, I can't give you some wiggle room on deadlines or something like that that might be found in the court rule. I have to hold you to the same rules. Do you understand that?
Mm.
You understand that, Mr. Hudson Bey?
Can you repeat that one more time for me, please?
Sure. I'm going to get Mr. Franklin in a breakout room here while I'm doing that. I think we got him squared away. All right, so Mr. Hudson Bey, back to the question at hand. Do you understand if you go forward today representing yourself that I have to hold you to the same standard as it relates to court rules or rules of evidence or anything else as I do attorneys? Do you understand that?
I comprehend.
Okay. And knowing that you still wish to go forward on your motion today representing yourself? You want to go forward representing yourself today, recognizing the court has to hold you to the same rules?
Yes.
Okay, very good. All right. All right, Mr. Butler, do you believe the court's complied with 6.005?
I do, thank you.
Okay. I do find that again this morning, Mr. Hensley Bey's waiver of his right to counsel and his request to continue to represent himself has been done knowingly, intelligently, and voluntarily. It's unequivocal. And I think the court also can rely on the prior times Mr. Hensley Bey has been in this courtroom. It's been numerous. His answers have always remained the same with his desire to represent himself. He's always acknowledged that if he did need counsel, he would retain counsel, or that he would exercise his right to request court-appointed counsel. The court's also satisfied that it has, again this morning, explained the dangers of self-representation to Mr. Hensley Bey and that he'd be held to the same standards as other members of the bar or other individuals appearing before the court. So I'll allow him to continue with his self-representation. And then Mr. Hensley Bey, you're welcome then, sir, at this time, then to give the court any argument you'd like on your motion here that appears to be a request to hold the proceedings in abeyance, a stay, pending your request for the Supreme Court to look at this matter. What would you like to state in support of your motion, sir?
Excuse me, pain. I'm coming. I'm just gonna read my motion. Defense motion for stay of execution pending appeal and bond to be waived. Come now, Milton Hensley Bey, in aforementioned case with a motion to stay. Defendant moves for an order staying execution of or any proceedings to enforce the final dispositions judgment entered in favor of Ione County Prosecutor Kyle Brandon Butler on January 8, 2024, pending disposition of defendant's appeal, which was filed with the Michigan Supreme Court on February 8, 2024. Defendant further moves that as defendant is indigent, no superseded bonds be required by the court, or if one is required, that no sureties be demanded. This motion is based on MCLA 600.2605 on MCR 3.604L. In support thereof, I am writing to request a stay of proceedings pending appeal in the above mentioned case. The purpose of this motion is to prevent irreparable injuries to the defendant appellant if the request stay is denied without causing harm to the appellee or the public interest if the stay is granted. Nature of irreparable harm. The denial of due process during the trial proceeding has resulted in specific irreparable injuries to the defendant appellant. The right to a fair and impartial trial is a fundamental aspect of due process under the Constitution. The denial of a continuance and the subsequent trial proceeding, which precluded critical evidence, have impeded the defendant appellate ability to present a robust defense. Denial of continuance. The defendant appellate motion for a continuance pending discovery was denied. Limiting the time available for adequate trial preparation, this denial directly infringed upon the defendant appellate rights to present a meaningful defense. Trial preclusion of evidence. During the trial, the court's ruling led to the exclusion of critical evidence sought by defendant appellate. This adversely affected the defendant's ability to mount an effective defense and deprive the defendant of a fair and impartial trial. Potential for sentencing before mandate. A particular concern is the risk that the trial judge may issue a sentence before the appellate court can issue a mandate. Such premature sentence will cause irreversible harm to defendant's appellate, as the appeal process may subsequently reveal errors or injustice in the trial proceedings. Lack of harm to appellee and public interest. Absence of harm to appellee. Granting the request stay will not cause harm to the appellee. The plaintiff appellee's interest can be protected without jeopardizing the defendant's appellate rights to a fair appeal. Public interest court consideration. Upholding due process rights is the public interest. Ensuring a fair and impartial appeal service and broaden goals of justice. And indigence of defendant. The defendant appellant is indigent and therefore should not be required to post supersede bonds. Conclusion. I formally request that the court grant a stay of proceeding pending appeal and, if necessary, waive the requirements for a superseded bond or, in the alternative, allow the defendant appellant to proceed with surety duty to indigenous. See attached proof for appellate court's filing in attached exhibit. Closing. Express appreciation for the court's consideration of the motion and provide contact information for any further communication. Supreme Court case number is pending. I also reserve my right to amend this motion and more grounds to be argued or attendance. Thank you. Yeah.
Okay, Mr. Butler, what's the people's position here?
Thank you, Your Honor. This motion is very similar, if not identical, to what he had previously filed, so our response will be the same. The only difference is that we have received an order from the Court of Appeals, and that was dated January 26th, in which the Court of Appeals dismissed the defendant's claim for appeal. So then the defendant did file then with the Michigan Supreme Court, and that same day that he filed, the court rejected his filings. So there isn't anything that's currently filed, appropriately filed, in either the Court of Appeals or the Michigan Supreme Court at this time that I'm aware of. So we would ask that you then deny the defense now second motion for stay.
All right. So it is accurate that the motion before the court today is similar to the one that the court denied back in January 23rd of 2004. At that time, there was a motions filed in the Court of Appeals. It was the court's belief that they were premature at that time, and then a January 26 order from the Court of Appeals dismissing those orders or that request for review as not being right in essence. And then Mr. Hensley Bey has filed something with the Michigan Supreme Court. I don't know what the status of that is. The prosecutor has been, hold on, sir, let me finish, and then I'll let you say what you want. And prosecutor suggested that those filings were not accepted. I don't see anything in the file whether they have or haven't, and it does not impact the court's decision regardless of what's going on here today. But if I could, in a thumbnail, identify the appeal that the request for stay that Mr. Hensley Bey filed earlier, this one today, are his attempt to have appellate review of different trial court decisions that were made during trial. And that review, again, I don't think is appropriate for any appellate court until there's a final judgment, meaning sentencing. We haven't got that far yet because of these motions. So again, I don't believe that there is any legal justification, a court rule that would suggest that the court is required to grant a stay. Court is not going to grant a stay for all the reasons I've stated on the record here, and that in essence, what Mr. Hensley Bey is attempting to have reviewed is something that can only occur after we have a final judgment, which is sentencing. And then the entire record of the trial, and motions and anything that occurred prior to that date can be reviewed then. And he'd have an appeal of right, as I've mentioned in the past, because of the verdict after trial. So it wouldn't even be the lesser request of a claim of appeal. I'm sorry, seeking leave to appeal. He'll have a right to review of the trial and all decisions that went into it. So respectfully, Mr. Hensley Bey, I'm going to deny the request for a stay here today. Mr. Butler, I'd ask that your office prepare an order indicating the same, and let's make sure so that it's easy to track, or as best we can, that the language that Mr. Hensley Bey has used is in that order. It's denying his defense motion for stay of execution pending appeal, bond to be waived. All right, that was filed on February 9th. And then Mr. Hensley Bey has promised, so I'm denying the stay, but do you have a question?
Yeah, I mean, the only reason why the appellate court, one of the reasons why they denied the motion, because I don't have the transcripts yet, and I don't have any information saying that the Michigan Supreme Court denied anything, because they. Well,
that's what I said. I don't have anything either. But so here's the thing: I'm denying the request today. Now the Supreme Court, if they sign an order that says, "Wait, we're granting your request for a stay," then this court has to follow any orders that would come from the appellate courts. I don't have anything in the file that would suggest that.
Okay, but you do have my paperwork that I did file with the Supreme Court, and you have the numbers on everything. The date that I filed.
I have what you have titled Notice of Appeal to the Supreme Court of Michigan, and
okay.
The case title is TBD. I assume to be determined. Yes. So that is in the file. It's received on February 9th.
Yeah, I can't do nothing until I get those transcripts, though.
Okay, so make sure you respond to them and get that completed, because I don't want you to be violating the terms of your bond or something of that nature. And I'm not suggesting that you would, because you always appear and you're always polite and respectful. But they're going to be reaching out to you to get that scheduled and get a sentencing date. Okay, sir?
Okay.
Okay, you are free to sign off. Thank you, Mr. Hensley Bey.
All right. I come today and get the order that the denial.
I didn't catch that last part. What was that?
That order that he denied, you denied. Can I pick that up?
Mr. Butler's going to prepare that order. I assume that can be done today. I'll sign it, and then it'll be filed at the clerk's office, and you are certainly welcome then to contact the clerk's office for a copy so that you have it for your records.
Okay, gratitude.
Okay, sir, you're all set today. Thank you.
People be Milton Hensley, case number 23S18766FH. Defendant is present via Zoom from our jail. He is in co-per, I believe.
All right, Mr. Hensley, how are you today?
Objection. Malik Bey.
All right. So, Mr. Hensley, we've been through this before. I'm going to call you by the name that's found on the information here.
You have my nationality information. You have my.
So, Mr. Hensley, are you representing yourself today?
Propria Sui Juris.
All right. Are you representing yourself today, sir?
Propria Sui Juris.
All right. So, Mr. Hensley, I'm not certain what you mean by that phrase. All I'd like to know is that whether you're representing yourself today or not. We've had this conversation many times previously. It's up to you, sir. All right. So, Mr. Hensley, you don't have a response for the court?
Well, you don't know what Propria Sui Juris is? That means somebody.
The literal meaning of propria persona is a Latin phrase meaning in one's own person. In legal contexts, it simply means representing oneself in court without an attorney, also known as appearing pro se. And the literal meaning of sui juris is also a Latin term, meaning of one's own right, referring to a person who possesses full legal capacity to act on their own behalf. These terms can be used in legitimate legal contexts, but sovereign citizens twist their meanings to fit their narrative. Sovereign citizens believe that by appearing pro se, they are asserting their status as a natural person who is not subject to the same laws and regulations as their legal person or straw man. By using sui juris, they aim to reinforce the idea that they are not subject to the laws and regulations that apply to ordinary citizens. They believe that this status exempts them from following laws, paying taxes, or adhering to court rulings. In reality, none of these terms provide them with any special status or immunity from the law, so their refusal to engage with the legal system in a conventional way often leads to delays, contempt of court charges, and eventually harsher penalties.
It means somebody presenting themselves.
All right. So is that what you want to do, is represent yourself today?
I'm presenting myself, Islam, yes.
Okay. And then, as we've talked about several times, do you understand that representing yourself can put you at a disadvantage to other folks like the people who have attorneys that are representing them? Do you understand that?
No, I do not.
Okay. What don't you understand about that?
None of it.
You don't understand any of it?
I don't understand how the disadvantage.
You don't understand what?
Did you say the disadvantage?
Yes.
How's the disadvantage? In what term? In what manner?
So the disadvantage would be that they're familiar with the rules of court, that they're trained lawyers and the rules of evidence and things of that nature, things that we've discussed many, many times.
So are we talking about law, or are we talking about codes?
We're talking about statutes. We're talking about court rules. We're talking about case authority. Do you understand that you could be at a disadvantage?
I understand law. Are we discussing law or the
I'm not going to play this game. Hey, Deputy, I want you brought over here in person. We'll put this all on the record. We're going to put this on the record in person. We're going to get Mr. Hensley sentenced today, and we'll make a complete record, as complete as we can, but I want to do that in person because we can do this all morning via Zoom, and it's just not very conducive to that. So if he can be brought over, and then we'll continue with our document.
Get over here.
Until we see him here. What do we have next that we can do?
Yes,
Sure.
I think
A few moments later.
Case number 23S18766 FH People v. Milton Hensley Bey Jr. Defendant is present. He is in person. He is in pro per. Today's the temperature for sentencing. And in front of him at the podium, I've provided 2 copies of his right to appellate.
All right. So, Mr. Hensley, we are back this morning for circuit court sentencing. He's appearing in person. We did try to start this earlier with him remote at the jail. It just made more sense for the court to have him present where we're not trying to talk through Zoom. So, Mr. Hensley, here we are again today, sir. First, I want to start with this. When I arraigned you a couple weeks ago, you were given the opportunity to request court-appointed counsel, and you were also given the opportunity for the last several months to retain your own counsel. Are you representing yourself today, sir?
For objection, for the record, let the record reflect. My appellation is Malik, title is Bey. Moorish American national under Islam.
Anything else?
Propria Sui Juris.
All right. So, sir, the information that I have in front of me has your listed name as Milton Joseph Hensley Jr. So we've been through this before. Respectfully, I'm going to call you by the name that is listed in the information, Mr. Hensley. So, Mr. Hensley, do you wish to proceed by representing yourself today, sir?
Over my Fifth Amendment right.
All right. You don't wish to answer any questions from the court?
Over my Fifth Amendment right.
All right. So you're not going to answer the court when I'm asking, do you wish to proceed representing yourself today for circuit court sentencing? You wish to do that, Mr. Hensley?
Objection. My appellation is Malik, title is Bey.
All right. So then let's get this on the record. As far as the PSI, Ms. Bond, it would appear that the court has a copy of this. Mr. Butler apparently has it. And then what do you know about Mr. Hensley receiving this copy?
That he was emailed a copy, and it's my understanding one was picked up at the office by someone.
All right. So, Mr. Hensley, have you had a chance to review the pre-sentence report, sir?
Objection. My appellation is Malik, title is Bey. And for the record, you have my nationality information within your files. So you know my appellation.
All right. So when was our PSI completed, Ms. Bond? Okay.
As he was arrested on the bench warrant, there's an additional 12 days from 4/18 of 24 to today.
So I also want the record to reflect, I've seen Mr. Hensley several times as it relates to sentencing. He had been appearing for all of his court appearances. He had been cooperating with the court as it relates to expressing his desire to represent himself in these proceedings. He's never wavered from that, which is why the court is inquiring again today. I recognize that sentencing is an important part of the circuit court process, is why I'm asking. However, the court is balancing that with the idea that this circuit court sentencing date has been delayed several times, and the court can't help but glean at this point it just appears to be a delay tactic. The court, we sift that back through the dates, has given Mr. Hensley several times to hire counsel. He expressed that interest. Again, it appears in hindsight that it's simply a delay tactic. Here this morning, in response to the court's questioning, he does not appear interested in answering the court's questioning. Again, it appears to be a delay tactic. I am comfortable that the pre-sentence report has been provided months ago to Mr. Hensley. I am comfortable Mr. Hensley has been given ample opportunity either to retain counsel, to ask for court-appointed counsel. And therefore, the court's going to proceed with sentencing today. I can't continue to allow this delay of the matter in what appears to simply be at this point, series of incidents and responses, or lack thereof of responses, simply to delay the matter. I know Mr. Hensley's been engaged with this. We have several filings that are not court filings that he has continued to send to the clerk's office, some of which he has referenced, none of which have anything to do with the case and or the court's requirement to get him sentenced now that he has been convicted several months ago of these crimes. So what I'm going to do is I'm going to start with then Mr. Butler. As it relates to the PSI, are you aware of any corrections, additions, or deletions that need to be made with it other than what we've already placed on the record with probation?
I would just ask the court to take a look at offense variable 4 regarding psychological injury to the victim. We did receive a victim impact statement. It looks like it came from Robert, who was the male occupant of the vehicle. In this case, the victim. We received that just this morning, about 2 hours ago. By email. So I could read that. I do believe it references facts to validate scoring for week 4.
All right. So why don't you read that?
Okay. This is from Rob L. He says, I do have things to say to the judge and the proceedings that I would like to be read during the sentencing below. Your Honor, I apologize for not being here in person today, but I could not find the time again to keep seeing this through. The amount of stress and anxiety Mr. Hensley has caused my family is downright disgusting and infuriating. Pull a gun on a family driving down the highway for nothing more than getting out of his way, not getting out of his way fast enough is obscene. My daughter, who was only 9 years old at the time with special needs, was terrified, and it took months for her to feel comfortable riding in any vehicle again because she was scared someone was going to cut her life short for seemingly no reason at all. My wife had to start and is still in therapy over this whole situation, which has thankfully helped her anxiety levels to become manageable, but also is not covered under our insurance. So it's cost us quite a large sum of money, and that brings with it its own stresses to our family and social life. I find myself driving and cannot seem to relax because anyone I see speeding up behind us reminds me of the terrible people in the world and just how ignorant someone can be with disregard for others' lives, including those of its own family and child in the car. Being that there are previous charges against Mr. Hensley for almost the exact same situation where he brandishes a gun and threatens to kill people because of his unchecked aggression and inability to safely operate a vehicle, which then turns to road rage, I plead that the court recognize this man is a danger to society whose blatant disregard for human life will eventually cost someone to lose theirs, if not his own. Because of all the pain, sufferings, financial burdens, and overall creation of trauma and issues in the many lives he's affected, I petition that the court give Mr. Hensley the maximum sentence possible for his crimes, that my family and others he's affected may know some semblance of peace. To Mr. Hensley, despite everything you've done to my family over this very long process and the disdain I have for you as a human being, I hope that your time behind bars will allow you to see life differently and that you can truly find the error of your ways to become better for yourself and your family. So with that statement, I think we have 2 individuals that are reported by Mr. Stagel to have suffered emotionally from this, his 9-year-old daughter and his wife, both of whom were in the car at the time. I think that would validate more than 10 points.
I object to that.
Hold on. So, Mr. Hensley, what is your objection?
Tell him prove everything he's saying. If his wife and everybody went through the trauma, show me the doctor bill and the report that he went through it. Because I can't believe somebody that would slam the brakes on the interstate at 75, 80 miles per hour to deal with trauma. You could have killed us and everything behind me. Ain't no such thing as you got trauma for you slamming your brakes.
All right.
Prove the accusation that he's making. Prove it.
All right. So, sir, I am going to grant
the script like you coming from a movie or something.
I'm going to grant the request for scoring OB4 based on the victim impact statement here. It does appear to meet the definition. Now, OB4, for the record, psychological injury to a victim could be scored 10 points if the serious psychological injury may require professional treatment, and in making the determination, the fact that the treatment has not been sought is not conclusive. First, we have the issue of the 9-year-old in the car, apparently with special needs, and dad, victim, has expressed in that statement that was just read into the record how this is still affecting the minor child. And that makes sense in court as it relates to somebody that's 9 years old and was observing somebody pull up next to them and point a handgun at them.
Still haven't been proven for the record.
Mr. Hensley, you've been convicted of that, sir, by the court.
We're gonna have our day. We will have our day.
please let me finish, and then
Yeah,
I certainly will give you the opportunity to address the court before sentencing. And then also, pursuant to the statement that was just read into the record from the wife, who also was in the car, according to the testimony at the trial, she is not only suffering from the effects of this, has sought treatment and continues to seek treatment, which is in line with the OV scoring guidelines that professional treatment may be required, in fact has been, and is still being engaged. So we'll score 10 points for OV4. So that will change our total OVs to 35. And does that change the level?
Good, Your Honor, changes it to a level 4.
Nothing else from victims?
That's correct, Your Honor.
And then anything on behalf of then the people?
Your Honor, the recommendation on the 0 to 17 guideline range is 12 months on count 1 and 2, and 2 years on count 3 preceding the count 2 sentence. The people did initially support that, but with the change in the sentencing guideline range, obviously this does open up, Your Honor, to more opportunity for incarceration if you so choose, and we would leave that at discretion. But otherwise, we ask that you at least follow the recommendation as intended by Henry.
All right. So, Mr. Hensley, I'm going to give you the opportunity before I ask you to address the court for sentencing. Do you have any additions, corrections, or deletions as it relates to the pre-sentence report?
Thing I can say.
You have any additions, corrections, or deletions?
All those accusations are false, and none of them have been proven.
Okay.
Not one. And he talking with this story.
As it relates to this report, do you have any
I don't have
additions,
no report.
corrections, or deletions? Excuse me?
No, I don't have no report.
All right. So, as it relates to sentencing, is there anything that you want to state to the court before a sentence is imposed?
You know, I have my medical information. You know, I have stage 3 cancer. You know, I have head trauma. You know, I have neck and back injury or something with a dry foot. For the record.
Anything else then, Mr.
That's it.
All right. So Mr. Hensley has provided, it is accurate, information regarding different medical issues that he has, that he is suffering and is suffering today, as a matter of fact. However, as the court sat through this trial, it's clear to the court that what Mr. Hensley was engaged in is troubling. The testimony of these victims, where they were traveling on westbound I-96, minding their own business, when Mr. Hensley's vehicle comes up behind them at a high rate of speed, the victim described with great clarity how close Mr. Hensley and his vehicle were to them, to the point they were extremely uncomfortable. Did not, hold on, Mr. Hensley, let the court finish, okay? To the point that they thought they were going to be struck. The victim, I recall, describing being unable to even see the front of Mr. Hensley's vehicle. That's how close it was, meaning the grill, headlights. I recall the testimony. And that they immediately got over. Victim then went on to describe that Mr. Hensley pulled up next to them and pointed a handgun in this manner, of course, pointing over to the right and directly at these individuals. The victim described how he reached back, started to shield his family, and that they were getting down as best they could. Now, all of that, I think, is certainly actions that would cause the victims here to feel their life was in danger. Somebody points a gun at them. The fact that somebody is tailgating back closely behind them on the highway at speeds of 70, 75, 80 certainly puts people in danger, could cause people to be incredibly uncomfortable about what's going to happen next. But it's a long way, Mr. Hensley, the court saying, having sat through the trial, you create the situation by driving in a manner that makes these folks uncomfortable, by coming up on them at a high rate of speed and following it now that closely.
Objection, man.
Mr. Hensley.
I drive a BMW. Anybody with an autopilot vehicle, you know for a fact it won't do that.
Right.
That's a fact.
So Mr. Hensley.
Not what he giving you on out of his mouth. A fact. An automobile will not get up on nobody. Automatically jam brakes. I told you
Trial.
BMW does that.
The trial is over. You
Oh,
had
it's
an
not over.
opportunity
It's not
to
over.
cross-examine those witnesses.
I did that, and you deleted everything I said.
Yeah, court
And
made
you
some
heard
rulings.
everything that they said was a lie.
So now you
And you know
need
it was
to
a lie.
let the court finish, all right? So the testimony was as the court has described, and there is no doubt that all of those actions Mr. Hensley is responsible for. That's the ironic part of it. He creates a situation that causes discomfort for these drivers, and then he's the individual that introduces a gun to the situation. Court heard 404B evidence that was remarkably similar, where Mr. Hensley is right on the bumper of a young lady, Grand Rapids, Kent County area, and then when she is very uncomfortable and pulls over and stops, Mr. Hensley again introduces a gun, pointing it at that individual. Now, I mention this because I'm not using that as it relates to a sentencing issue. I'm using that, and that it's clear Mr. Hensley drives in a manner that endangers other people, that causes them to report his activity to other people, and then when they attempt to evade, if you will, what Mr. Hensley has caused, then he introduces a gun to the situation. Now, Mr. Hensley, I don't have to tell you that it's fairly obvious that in today's world, right, today's world of shall issue CPLs, that even if you believe that somehow you're justified in displaying a weapon, and for the record, there's nothing in this trial, nothing this court heard with the 404B evidence or the incident at hand here that we're sentencing you on that would suggest that in any way, shape, or form that you were not responsible, that you had any legal justification to introduce a weapon to it. But even assuming in your own mind that you were, what happens with that in today's world is they would have a very easy avenue to articulate, I felt in fear for my life or great bodily harm, and assuming they were lawfully carrying a gun, could take action, shoot you, in other words. And I can remember just in Little Ione County, an incident that occurred just a few blocks from here, in which an individual was tailgating a lawful CPL holder going right down Steel Street over here. And so that individual, much like here, got over, pulled into the car wash to get away from this guy. And the guy behind him pulls right in behind him, much like in the 404B evidence I heard with you. And so what happens is the CPL holder, what is this guy doing? He's crazy. He pulls his gun. Now, you can argue whether he could articulate at that time whether he felt his life was in danger of death or great bodily harm. But regardless, so what happens is the tailgater, he then also was a valid CPL holder, and he pulls his gun. And guess what they did? They shot each other, and they both died. The ironic thing is maybe it's the one time that a government program worked 100%, because to get a valid CPL, you have to take this course, do all those things, and part of that is shooting your gun 15 times or something. I can't remember.
I worked on my own car. I knew about the CPL.
Yeah, well, my point is, so they both hit their mark, and they're dead. And it's started from something just like this. And so my point in demonstrating the story to you, retelling the story, is when you engage in this kind of behavior, it puts your own life at risk. Put your own life at risk. And that you are lucky that hasn't occurred to you, but you certainly have frightened the heck out of people with what I heard in this trial. You certainly were in the wrong, and you're not a valid CPL holder. That's the other problem.
Because I don't need it.
All right. Well, I recognize you think that you have some fundamental rights that I'm not aware of found either in state or federal constitution, and you certainly can take those up on review, right?
I'm already in Western District Court already.
So that's fine.
Okay.
You can appeal anything that you'd like, any reason you think you have a valid appeal, but they're simply not found in state or federal constitution. And so here we are today. So that's how we end up with a carrying a concealed weapon, felonious assault, felony firearm. And what the court likes to do, Mr. Hensley, as I'm reviewing this, I will say this, I'm weighing positively in a positive manner here. You stand before the court at age 50, you don't have any prior criminal history.
Exactly.
Which is somewhat remarkable when I heard about the 404B evidence. So
Exactly.
I don't know how that didn't result in some sort of crime, but it didn't. And I'm recognizing that, and I'm going to recognize that in the sentence I'm going to impose here in a minute. We do have the sentencing guideline now, which is 5 to 23 months. Court likes to think about the middle. The middle of 5 to 23 is going to be 14. And I also want to recognize that you don't have any prior criminal history, and that I will also recognize until lately that you've been cooperative with the court. You showed up to court, that you, as far as I could tell, did your very best to represent yourself, and were adamant about doing so and took this matter seriously. All of those things, I think, are things the court can weigh that are positive to you. The negative, though, sir, is the outcome of this is your actions and one causing this and then making it worse with introducing the gun and pointing it at this family on the date in question.
Can they prove that?
They did prove that.
No,
Beyond a reasonable doubt at
did
trial.
not.
I recognize you disagree with that.
Because you had
asked the court to decide it,
photos,
and
you
the
had
court
video,
decided it.
you had somebody mouth.
Those are all
Yes.
evidentiary issues that you, again, can explore on appellate review, sir. You're welcome to do that.
Yes.
All right. So as it relates to the carrying a concealed weapon. All right, so carrying the concealed weapon is count or charge number 1. Court's going to impose a sentence of 12 months to 5 years. That's under the minimum guideline range of, or the middle, I should say, of what the court was looking at 14 months. So it'd be 1 year to 5 years with the Michigan Department of Corrections, and you do have credit now for 14 days that you have previously served. As it relates to the felonious assault, now this would be charge number 2. The court's going to impose a sentence of 1 year with the Michigan Department of Corrections to the statutory max of 4 years. You will receive credit for 14 days that you have previously served. And then as it relates to count 3, this is the felony firearm. The court is required, Mr. Hensley, to impose a sentence of 2 years with the Michigan Department of Corrections. And then counts 1 and 2 that I mentioned earlier will be served concurrently with each other, but this count 3 by statute is required to be served consecutive with and preceding these other 2 counts. So 2 years with the Michigan Department of Corrections. As it relates to the monetary obligations, Mr. Hensley, the court is required by statute to impose $130 as a crime victim rights assessment. Court's going to impose court costs in the amount of $1,500. There'll be a $60 DNA testing fee, and then required by statute are the state costs in the amount of $68 on count 1, $68 on 2, and $68 on 3. All right, so Mr. Hensley, you do have a right, and this is something you're interested in. You've expressed that interest to seek appellate review of the sentence the court has imposed. If you'd like to do that, you have 21 days from today's date to make that request. You have the appellate paperwork there.
Right in front of him along with the pen.
All right.
He's already in the district court. You want the case number?
So hold on. So you have 21 days from today's date to make that request. All right. If you want to ask for a court-appointed attorney as it relates to this appellate review, you have a broader window of 42 days to make that request. Okay. Because you were convicted at trial, you have an automatic right to seek this review, meaning that if you ask for that review, then the appellate court will have to take a look at it. All right. So if you can, then there's a pen there. I need you to sign. There's 2 copies of that. One for you to keep, the other one for you to initial and date that you've received it. So if you could do that for me, sir, it's right there on the podium. All right.
You can take that with you. I'm not signing anything.
All right, so for the record, Mr. Hensley Bey is indicating you don't want to sign that, sir?
I'm not signing anything.
All right, so for the record then, though, I am going to send back with the deputy his copy of the appellate review form. I'm going to place the unsigned appellate review form here. Mr. Hensley, only because we've dealt with this case for so long, if you want to explore these, though, this form is important to you, okay? I recognize that you are refusing to sign it or acknowledge it for the record, but this is something that you want to file timely if you want appellate review of this.
They don't have jurisdiction. So if they don't have jurisdiction, neither do you.
All right. Well, I think that the court has jurisdiction, and if you want this reviewed by a Michigan court, then you need to file that. But I'm going to give that to the deputy. We'll keep it in your possession, and you're free to go.
All comments, viewpoints, interpretations, and insights expressed in this video are for education and entertainment purposes. All individuals featured in the video are to be presumed innocent until proven guilty in a court of law. Please do not attempt to contact, locate, or engage with any individuals featured in the video.